Mr. Fisher is the main brain power behind all the Holocaust cases in the last decade or so. And also we have a co-presenter, Professor Wang from China. Yeah. Also, being tackled around between Japan, not only China, but also with Korea. So we need to incorporate all this information together. And so today, we get Professor Wang along with Barry Fisher to give us, moving forward, what will be the legal venue for us to learn from the past. And Barry just had a small medical procedure, and we really appreciate his presence here. And he went a great length to be here, to wait patiently. Thank you very much.
So, the idea to take a break now from this long morning and these great presentations is a good idea, and I will not be too upset if you take a break. Okay, you can hear me okay?
Yes.
Good. Because the time is limited, and I wanted to say a lot of things, I sort of prepared it so that I wouldn't be looking around and whatever. So, anyways. So a little bit of formal stuff, and then I have some suggestions of what really could be part of the program for the future. So, but to begin, as the 20th century ended 14 years ago, and a new millennium began, Japan's wartime allies, Germany and Austria, along with Holocaust profiting Swiss banks, settled all remaining unpaid victim claims for over some $7 billion US, with full acknowledgement and apologies, all in an effort to close the book on their horrible, stained past. This resulted before the end of 1999 from class action lawsuits that I and other lawyers brought, and most importantly, multinational treaties between Germany, Austria, and many countries for which I served on the 11-nation negotiating team, and along with representatives of those countries, I was a signer on those treaties. Europe tried to move forward into the 21st century, but Asia remained a total prisoner of war and of its colonial past because Japan refused any resolution whatsoever, instead dragging its last century of horror deeper and deeper into the new century. And this triggered many reactions, including dozens of court cases in the US that I worked on, and cases in Japan and other countries, and other reactions. As you all know, the horror of Japan's wartime atrocities are of enormous scope and years. Japan's Asian-Pacific War, covering most of Asia and the Pacific region, began on Zhou-Yi-Ba, 1931, invasion of China, merged with World War II, and ended in 1945. But the 1931 invasion of China was staged from the Korean Peninsula, which Japan had already brutally controlled for 21 years since the 1905 treaty resulting from Japan's winning its war with Russia. So it spanned 40 years, from 1905 to 1945, and the remnants continue to this day. Today I want to briefly review the evolution of the Japan redress movement, particularly since my involvement in 1999, when after 5 years of working on the Holocaust Europe cases, I made contact with the Global Alliance and Ignatius Ding, and with Korean groups to begin an initiative, hopefully paralleling the German and Austrian strategies I worked on in order to pursue redress with Japan. I'll talk a little about the successes on the Europe side, which continue to this day, including the expansion of the German reparations program and reparations of looted national treasure. And there have been advances also on the Japan side on looted art and regarding the comfort of women in a recent Korean Supreme Court decision declaring that the 1965 treaty that Japan relies on for saying that there was that finished all possible claims, that the Supreme Court said no, that didn't resolve the women's claims, And it has implications for China, which Professor Gwen and I talked about yesterday, and which he's going to speak about today. And I want to discuss how we can move forward towards Japan redress, including the memorial monument movement, all necessary for the world. More forgets and no living victims remain. So, I want also to briefly cover the Holocaust in Japanese cases I worked on, and most importantly, the interrelationship of the cases with the GA and other political organizations in many countries, in Korea, Japan, Philippines, and elsewhere. And also advances by the international redress movement, notwithstanding the great handicaps caused in major part by the profound difference between the experience of Japan and Germany's victims. Germany, encouraged by the United States, recognized its past and moved forward on compensation. Japan, also encouraged by the United States, but this time in the exactly opposite direction. Exactly opposite direction. The U.S. opposed any apology and refused to compensate. See Japan refusing to compensate its victims and fighting all lawsuits to the bitter end, with the U.S. joining in. Now, there are cultural, psychological, historical, and political factors that help explain the difference between what happened on the Europe side and the Asian side, which I don't really have time to talk about today. I've written about this in law review articles, but this profound difference was the subject of some articles that Iris Chang and I wrote that were published in newspapers around the country, which I think raised historical and political consciousness about this issue. Towards the end of 1999, the German and Austrian issues were being settled, and I began focusing on their ally Japan and the rights of its victims. At that time, as I say, I made contact with Ignatius in San Francisco and with Korean groups. In September 1999, Ignatius and I went to Tokyo and met with Japanese lawyers and organization leaders, and we were treated sort of like we were from Mars. I mean, the idea of cooperating and people from China and the U.S. having anything to do with what they were doing. But it actually began a change, and it began cooperation on a worldwide redress strategy. In December 1999, there was a huge redress conference in Tokyo, which we participated in. I think I was the only American that spoke there. At the beginning of 2000, I flew to Beijing to meet with Wang Xuan for the first time, and a young lawyer who worked with her, Sun Jing, and we met with victims and some academics, but the Chinese government allowed, as I understood, no victim organizations, and there hadn't been a government-approved academic conference up to then. But shortly after, within 2 months, the government changed its policy, and a university in Shanghai was permitted to hold an international conference on the comfort women under the leadership of Professor Su, who I met for the first time. And I, again, was the only American invited to speak. At that conference, I met victims and organizations from the Philippines, from the former Dutch West Indies, from North Korea and elsewhere, and we formed a kind of a solidarity group to work on redress issues. And there have been meetings in The Hague and Pyongyang and China. The GA hasn't been involved for some political reasons, but I think that is something that it might want to consider in the future. Japan, the wartime redress movement resulted on the Japan court side in about 100 cases, but there were also cases amongst China and Korea. The cases were also filed in the United States beginning in 1999, which I was involved in most of them, including the landmark Crowne versus Japan, the only U.S. Comfort women case that was brought with GA assistance in Washington, D.C. It involved a big press conference, demonstrations at the Japanese embassy, was filed on Joe eBay September 18, 2000. And it was a case that went up to the Supreme Court a couple of times, and it really did whatever lack of success in finality because of a lot of developments that were happening, including, which I won't go into, but I've written about it, in politics in Washington and the Bush administration and executive powers issues. But it did get a lot of press and raised a lot of consciousness and played an important role in the international redress movement. There were other cases, including a case called Zhang versus Mitsui. It was brought on behalf of Chinese slave laborers, all living today, perhaps they're still alive, in China, in Hebei and Hainan provinces. And at one point, they had to come to Los Angeles for their depositions to be taken, and were accompanied by Beijing lawyer Sun Jin, again, who works with Wang Xuan, and with the assistance of the GA. The Japanese courts were, of course, extremely hostile to the claims, and there were little to no successes there. There were some settlements, including the very controversial Kajima settlement. It's important to keep in mind, though, that all of these cases filed by me and others in various countries were all part of an integrated, coordinated strategy, a redress strategy that involved many organizations and meetings and decisions about bringing the cases, all with the important objective to raise historical and political consciousness of public officials and citizens throughout the world. And this redress movement, it was integrated with other things, the petitions to government parliaments and congresses to pass resolutions calling for redress that ultimately, to this day, were issued by many, many countries, including the United States. There were issues such as the, although he's just walked out, because Ignatius, oh, he's come back, he's so shy. But, you know, our cyber warrior, amazing success on the 42 million signature petition that he led to prevent a permanent seat on the UN Security Council of Japan until it resolved these claims was an amazing feat. I don't know if it could be repeated, but you know. And then there were UN investigations. There was the Tokyo war crimes trial that focused on the comfort women, and so many other things that the court cases were all part of and are still. And the recent developments in China are important, and there are developments in Korea that are important. And so it's far from over. Included in this movement, of course, is the growing memorial monument movement, which has drawn highly financed Japan money in efforts to defeat it. I want to tell you something about the case the Japan side has spent millions of dollars challenging, which is the Comfort Women Monument in the small California town of Glendale, which is near Los Angeles. This is a case that I've participated in on behalf of GA. On July 30, 2013, Glendale unveiled a very modest and beautiful Comfort Women Peace Monument in its Central Park. On February 20, 2014, two Japanese Americans, Michiko Jinjuri and Koichi Mera, as well as an entity that ripped off the name of the Global Alliance, with calling itself Global Alliance Historical Truth US, which had just been formed a couple of weeks before and doesn't have official nonprofit status or anything. They filed a lawsuit in LA federal court seeking a federal court declaration that the installation of the monument was unconstitutional and that it should be ordered removed. The case alleges that Gingery and Mira avoid using the bark because they are offended that it stands as an expression of disapproval of Japan and the Japanese people. The Global Alliance Historical Truth, that fraudulent organization, was created itself by a right-wing group in Japan that seeks to restore what it views as Japanese honor lost after the surrender of World War II, and promotes the idea that there was absolutely no Japanese aggression during World War II, and that Japan's comfort women program never happened. The group was formed by another Japanese organization called the Society for the Dissemination of Historical Fact. And its chairman, Hideaki Kase, has written such things as the following. Japanese authorities never abducted women, never forced them to become comfort women. Accusations involving comfort women, Japanese aggression, and the Nanjing massacre are completely fabrications and without fact. Another founder of this crazy group, but it's, it's out there, but it's not so isolated and it's not so small, as a matter of fact. Another founder is a guy named Nobukatsu Fujioka. He led the Japanese school curriculum, so-called reform movement in the 1990s that set out to what they considered correct and whitewash Japanese past by removing from textbooks references to be associated with what it called its dark past, issues such as the comfort women that might make Japanese school children uncomfortable. Miss Gingery, when interviewed by Forbes magazine, was asked whether she really believed that the comfort women are lying. She totally avoided an answer and just said, well, I think there's no place in America for such monuments. They should be located in Korea and Japan. Her co-pilot, Mr. Mira, says he avoids taking his daily walks in the park. But one thing we uncovered was that he lives some 30 miles away, very far from Glendale in the Pacific Palisades, much closer to Malibu and other places where people take walks. From the Japan Group website, it's clear that they raised millions to bring this attack as a kind of first line of defense against what they considered to be a movement that may include other monuments throughout the country. They argue that the technical argument is that this interferes with the executive branch of the U.S. government in its dealing with foreign policy because the whole issues involved with the comfort women are highly contested and unclear, which is obviously a phony matter. And I submitted a friend of the court brief on behalf of Global Alliance, and which set out the correct facts on who these people are, where they're coming from, and a lot of data about the comfort women. And the judge threw the case out, issued a judgment, one of the things that was mentioned yesterday, and it's certainly true and it's highly documented and it's something that was said in the papers, was that this program by the Japanese government was by far the biggest human trafficking operation in world history. There's never been anything like it. An amazing history. And most people don't understand that. And in a few minutes, when I get to the end, I want to suggest something that will help set the record straight and inform the world. So the court dismissed the case in the beginning of August, and the Japanese group filed an appeal. It's pending in the Ninth Circuit, Federal Court of Appeals. I intend to file amicus brief on behalf of GA within the next couple of months, and it'll probably be going on for a year or so. On the other hand, shortly after the case was dismissed, they filed a parallel lawsuit in the state court of California in Los Angeles, which is subject to all kinds of motions, which I think will be successful, and to throw it out at an early stage, and they will be charged with paying all of the legal costs of the city of Glendale. And I'm in touch with Glendale, and I'm keeping the GA posted on developments. So it's certainly time for, I think, more concerted actions by the Chinese American and Canadian Chinese communities, including more comfort women monuments. But also, for example, as a growing and successful worldwide movement has worked for the return of looted historical treasures, including art, libraries, historical documents, and more, this is an effort that has been, I think, remiss on the Chinese side. I'm wearing a little button of the 100th anniversary of Fudan University, and when I went there on its 100th anniversary, I met with the librarian, and we had a conversation about looted books and the treasures that were taken from China by the Japanese that are disseminated, that are in Japan, but maybe in Los Angeles and elsewhere in the world. And that is an important, growing, worldwide effort on and return of looted art. The Japanese have returned some art to Korea, and in the LA County Museum, there's some Korean objects that were looted during the war, and there's negotiations to return them. But there's art all over the world that was Chinese, books, valuable parts of the culture that should be returned, and I think that should be worked on. And earlier I mentioned, Spielberg and Hollywood and whatever. I think I may have mentioned it for the first time in Beijing in 2004 at the GA meeting. But China is increasingly in the film business and owning theaters, and it's very, very involved, increasingly. Chinese and Americans and Canadians should use their connections to help encourage a joint Chinese, US, and possibly Korean film industry production of what would be an absolute blockbuster historical drama that more than anything would tell the amazing and graphic story of the Japanese wartime slave ships and slave labor, of capturing people all over the vast Pacific region that they were operating and shipping people for sexual slavery, for slave labor, wherever they needed it, from taking them from Papua New Guinea to the Aleutians to the home islands, and it would include the capturing of Chinese soldiers and taking them to slave labor camps, including the Kajima coal mine, where soldiers, including the Limbao, one day said no and began a revolution, a revolt, the famous Hanaoka incident. And that incident, which is very much like what has sparked many movies and books about Spartacus, the Roman slave laborer who brought about a revolution and change, and even a mini-series that was on US television recently about Spartacus and this history. This would tell the story of what happened to Chinese people and others in the most dramatic and I think important way to help raise the historical and political consciousness of the world of what happened to the Chinese people and what the Japanese did. So in conclusion, Chinese in America and Canada and elsewhere should join with national and international redress movements on looted assets and all of these things for a future where the past history is remembered, not forgotten and repeated, and where finally Japan acknowledges, apologizes, and provides redress to the Chinese and other wartime victims. Thank you. So, some questions?
I'm from Toronto. We have a student, law school student, actually, right now is a law school student intern. He's researching particularly on this issue, the litigation issue of erecting the statue in America. The reason why we want him to get into this research is we want him to find out the basis of the legal basis of how this is ruled, and also in the future may be possible when we are erecting another statue in public space, then would it be possible? So is it possible for a student to connect with you?
Yes, I would encourage that, and I don't think that any community or individuals should fear the Japanese side on this issue. I mean, it's very crazy litigation. They're going to lose, and they're trying to, intimidate by raising money and having a big war fund, but this is going to fail in Canada, in the United States, and elsewhere.
Yeah. The reason why we want to do this is he's a Caucasian. Actually, every year we have an internship with the University of Toronto Law School, and after researching into this particular issue, he will bring this back to the classroom, and it will raise awareness, more awareness of the legal side of the the Asia-Pacific War.
Good.
Wonderful.
And I have worked on Canadian law issues. So.
Wonderful. Thank you so much.
Actually, the lawsuit that was brought about by the Japanese right-wing extremists would be beneficial, because instead of only a minor issue in the local community, now it's brought into a national and international arena. So very often, a ruling in the court of law would be an expression or a statement in the court of public opinion.
Right.
And I think that would be, I think we should take advantage of the ruling from the law court, so that other people would know how frivolous, the right-wing extremists are.
Well,
how they would like to influence public opinion in America.
Yes, well, it's even shameful.
Yeah.
And the word shame is something, that Japan is a shame-based, collective shame-based society, unlike the Europeans, and so that's something I've written about the guilt and shame and how the reactions are different, and why the negotiations were, much more difficult with Japan. But this, they're collecting all this money, making this noise, and losing may help, and if they do it elsewhere, may help increase the shame level to where it may have impact.
Yeah. Couldn't we even take advantage of it, and every time they bring this kind of lawsuit, to generate all kinds of negative publicity that sheds light on this kind of frivolous things, so that it rears back on them rather than works in their favor.
Right. Now, on that note, I might point out that the Korean organization that was behind the statue didn't want to get publicity, didn't want to exploit it, wanted to leave it to the lawyers, and the city of Glendale, which was the defendant, was offered some free lawyer work by a very large firm in Chicago that represents Japanese side entities. So, I mean, and the Korean group just stayed very quiet, and they actually didn't want, they contacted me, and they didn't want GA to file an amicus brief. But, I talked to Ignatius, and he talked to others about it. It was very important because the briefs that were being filed by the Chicago firm didn't expose who these people were, didn't say anything about didn't give any historical context whatsoever, and didn't try to argue it in a very narrow, legalistic way on U.S. constitutional grounds. But this is this has to be told for what it is. And so that's what this brief that we filed.
I would like to invite Barry to come back after Professor
Sure,
Wong
sure.
to present another view on the venues for incorporate some Korean development in the Supreme Court, the Korean Supreme Court. Then we can consolidate and all this idea. And also, I would like to ask maybe George and others can join. Maybe we develop a editorial and contribute editorial opinion and send it to New York Times. Because New York Times yesterday had this big article, and then we can respond and follow that. And we can talk about, and you can shame them, but their behavior is just endless. Then we can make a much bigger blast.
Thank you for Dr.
Thank you, Dr. Wong. He flew from Asia to Toronto and here, then back to Toronto and go back again.
Thank you very much,
It's a long
Dr. Wong.
trip. Dr. Wong and Flora, thank you very much, and we'll see you
Thank you very
soon.
much. Thank you very much. We appreciate it. Thank you.
Yeah.